rise. The Court of Appeals Division 1 is back in session.
Please be seated. For the record, this is December 2nd, and this is the time set for oral argument in our cause number CR24 0443, State v. Lujan. I see most of the same familiar faces that were here before, but I would remind you to please turn off your cell phones or at least put them on silent. Each side is allocated 20 minutes for the argument, and you're not required to use all of your time. If you want to reserve some of your time, you may do so, but remember that the time on the clock is the total time remaining. And these proceedings are being live streamed and will be available on our website for viewing. Make sure you speak into the microphone, and please identify yourself and your client at the beginning of your argument. We've read the briefs, studied the record, and discussed the case in conference this morning. Please keep that in mind as you present your argument here today. And with that, we'll hear from the appellant.
Good morning. May it please the court. My name is Michelle DeWalshy. I'm with the Maricopa County Office of the Legal Advocate, and I represent the appellant, Brandon Lujan, in this matter. I'm here today with my colleague, Grace Geiswhite, who is here to help me take notes. First off, the prosecutor's errors and misconduct in this case, it interfered with the jury's fact-finding duty. It undermined the truth-seeking, function of trial, and it deprived Mr. Lujan of his rights to due process and to a fair trial. So first off, I want to state that the record in this case, from this record, it is clear that the prosecutors at the trial level knew that there was a urine test that was taken from Mr. Lujan 9 hours after these offenses were committed. It is clear from the record that they knew that these were screened for amphetamines and that the test came back negative for methamphetamine. And we know this because the state told the court this on June 3rd, 2024. They told the court this, and they said that defense counsel had already, and I quote, established that at the time of the offenses, he, meaning Mr. Lujan, did not test positive for meth. And so there was no meth in his system. And so based on that, we know that the prosecutors below did know that this test occurred. They did know that it was negative for methamphetamine. They were also present in the courtroom when Dr. Cavini testified that, a methamphetamine in a person's system would metabolize out in between 24 to 48 hours of use. They did not object to that. They were present, and so they also knew about metabolization.
But are you saying drug use has zero relevance if someone brings up a mental health condition and says, I have a mental condition, if the state disagrees with the existence of that condition and says it could also be explained by drug use? Wait, if you're talking about a condition that your condition wasn't limited to the day of the event, the crime, I'm assuming that the testimony. So why isn't drug use relevant?
Well, drug use in GEI cases is very relevant, and we know this from the statute itself. It states that this can't be the result of acute voluntary intoxication. And so the problem with what the prosecutor did here is that with full knowledge that this test occurred, the prosecutor at oral argument invited the jurors to pretend that test did not exist, pretend that, and basically asked the jurors, repeatedly told the jurors, we don't know what was in his system at the time of the offense. And so that was a misstatement of the evidence that was presented in this case. Regarding your other question, which would be, is it ever relevant if there is historically, drug use? That too, according to the case law in Arizona, may be a factor that is relevant if it exacerbates that mental health condition that the experts all agreed was present in this case. However, in this case, we have 15.
Maybe the state's theory is it doesn't exacerbate it. It really explains it, that it's really just drug use and it's not a mental health condition.
Well, the problem in this case is that we have 15 years of medical records from the VA hospital, and he was diagnosed with PTSD by many different doctors. In none of those, in that previous 15 years, was there ever a positive test for methamphetamine.
Counsel, I hear you, but wasn't there other evidence offered at trial that he did use methamphetamine?
Well, the evidence at trial that he did use methamphetamine was from a family friend who also testified that he had never seen him use methamphetamine, had never seen him with paraphernalia, and only said that he, believed that the defendant had told him that at one time. But there was no evidence from an eyewitness saying, yes, we definitely know he used meth.
We take the trial record as it comes to us, and it strikes me that there was some evidence before the jury that he had used methamphetamine in the past.
Well, Your Honor, what that would have to be is a long-term methamphetamine use, and we really have no evidence of that in this case. We have evidence that...
What did his brother testify to about that?
His brother testified also, well, first of all, his brother told the police, right after the date.
I asked you.
So his brother testified that, he had never seen any meth use, but that he believed that they were using methamphetamine, my client and his wife. But there was no testimony of long-term use. It was just a belief on his behalf. I mean, I would think that the exacerbating a mental health condition would require more, but it certainly was improper for the prosecutor here to claim that, we don't know what was in his system, when in fact everyone in that courtroom except the jurors did know that there was not methamphetamine in his system.
What was the exact quote that you're saying was improper? I may just be misremembering. I didn't. Was the prosecutor saying we don't know what was in his system at the time of the crime, for the time of the murders?
That is correct. That's what the prosecutor had said, and it was at least 3 times in my memory. We don't know what was in his system, even blaming the defendant because there was such a long period of time, the 9 hours between the commission of the offense and the testing.
Even taking the expert's testimony is true that it dissipates in 24 hours. At the time of his, assuming that he used meth, that means at the time of the crime, he may have still had meth in his system.
Well, Your Honor, I mean, this would give carte blanche to any prosecutor to argue in any case that if there is any evidence that he may have used meth in the past, that even if there is a negative drug test.
Good arguments to make to the jury, but doesn't the jury resolve those kind of conflicts?
Well, I mean, the prosecutor is bound by a code of ethics. They have a...
But it's not technically inaccurate to say that it could have been at the time. We don't know, and it seems like the defense has a very good response to say there was a test taken after and it didn't show anything. Why doesn't that address that concern?
Well, Your Honor, I don't think that is a reasonable inference from the evidence that was presented in this trial. I mean, we do have the test 9 hours afterwards. I suppose theoretically, if he had used meth, 24 hours plus 9 hours beforehand, but that again requires a lot of speculation and is not based on the evidence that we do have, which is that, there was this test, it showed no meth in his system.
But you did have testimony from the brother saying there's long-term use. Why isn't that at least an inference that can be drawn? And if they're overreaching, why isn't it something that the defense can point out? The state's really overreaching here. There was a test that shows nothing to that effect. It seems different to say you can't draw an inference. It seems like it is an inference, and then the defense has the opportunity to explain why that's not the proper inference to draw. Well,
I would say that in this case, with this evidence, that would be a misstatement of the evidence. I don't think that is a reasonable inference, as I laid out in my reply brief in that case. But that also is just one one instance of numerous instances of prosecutorial error and misconduct, and including violations, basically trying to elicit evidence that the state would know would be false or misleading regarding, the pipe in Eloy, and also regarding whether or not there was a Rule 11 evaluation in this case, which the state clearly knew there was not when asking.
Let's go to the pipe. I mean, wasn't that immediately cleared up?
Well, it was not cleared up by the state. It was cleared up by the defense, and so the state, elicited that evidence after the direct examination of Walsh, in which, the only things that were asked were, was there ever methamphetamine-related paraphernalia found in any of these prior police incidents? The answers were no, and so the question to that same detective on, cross-examination as to, whether or not there was a pipe found, wasn't there, and leaving it there is really asking the jury to infer, something that is clearly misleading.
Boy, we would be really concerned if the defense hadn't cleared that up.
Well, the defense cleared it up, but I also, as I placed in, in my statement, it doesn't, in my briefing, it doesn't actually negate the prejudice. I mean, Walsh was obviously the case agent. He had to have his recollection refreshed. It only came out after he sat there on the stand and read the police report, and so it's not necessarily. I'm not sure how effective it would be in actually. In alleviating the prejudice, but also I think that this court can consider that in its cumulative error. Even if it was corrected, it can be considered in the cumulative error analysis, and so we would ask. I would ask that you do that. I would also, just to point out.
What are the other incidences that you believe show prosecutorial error or misconduct?
Well, so there was also the questioning of Dr. Potts about the, whether or not there was a Rule 11 evaluation. Dr. Potts said, no, not to my knowledge, and this was the defense's expert, the only expert that, would be testifying as to the belief that he didn't know right from wrong at the time. And so it was an important...
Did counsel object to all of that?
Did
defense counsel object?
No, defense counsel did not object. So it would be a, fundamental error review for the individual
why would
instances.
That be fundamental error if we're talking about the defendant's mental health, and there's a Rule 11 goes to the defendant's mental health, and it's a question of no one seems to have been concerned about competency to stand trial. It seems like once mental health is at issue, we usually kind of view that as opening the door to all things mental health. Does that not, why isn't that part of the analysis?
Well, I would just say that in this case, I mean, the question was asked on cross-examination, did you review any Rule 11 records? And Dr. Potts answered, not to my knowledge, no. And so the state could have left it at that, but instead the state went on knowing that there was not a Rule 11 evaluation and asked Dr. Potts, well, does that mean that if there were records, you didn't review them? And this really undermined the credibility of this witness, who was the key witness, the only witness that would be testifying as to the rightfulness and wrongfulness question, which is the question that the jury should have been considering.
Did Dr. Potts, in his direct examination, talk at some length about Rule 11?
He did, and he used to be, a part of that process with the courts. He did talk about it at some length, and that's why I think it was a fair question to ask, well, was there one in this case?
Right.
The answer to that was not to my knowledge, no. And so it was the pressing of the issue, and then using that in closing to suggest that Dr. Kirby, the state's expert, actually reviewed more voluminous records than the defense.
Did Dr. Potts supplement his opinion or his report?
Wasn't
that at issue at trial as well? I mean, some of these, I understand what you're saying, but it strikes me from my review of the record that there's some context here that informs what happened.
Yes. So Dr. Kirby submitted not one but two supplements to her original report. The second supplement, and this brings us into one of the other issues in this case, came after they were provided, Dr. Kirby was provided with the what I call the 11th hour disclosure, but the disclosure 5 days before trial began of these statements by my client's brother, that there was he believed that there was methamphetamine use, in the past. And so basically, I apologize. If you could remind me of your question, I just lost myself.
Sure. It was with respect to Dr. Potts and
Yes.
whether he provided a supplemental report, and that there were issues, at least as an interested observer of the record, about what experts had done and maybe not done that were presented in the evidentiary body and then argued to the jury.
Well, yes. So Dr. Potts did not provide a supplemental report. He never changed his opinion either, which is what Dr. Kirby did here.
And both those things come through from my reading of the record. So I guess I'm a little curious with the focus on the reviewing records, which seemed like was a fair point of examination for the experts.
Well, I think it was a fair point to ask whether or not the records that were reviewed, but clearly there was not a Rule 11 evaluation in this case. These prosecutors knew this. These are, career prosecutors, the head of the mental health unit. That is something that they certainly would have known. So to continue asking those questions.
No, and I get your point.
Error.
And had Dr. Potts not testified at some length about Rule 11 and direct, I think you'd have a far stronger point to make, but he did. Didn't he talk about doing hundreds of Rule 11 evaluations?
Well, yes, Your Honor, but he did not testify that he did it in this case. And so when he clarified that he did not, review any Rule 11 reports in this case, that really should have been the end of that questioning. What was improper
when I
was
read
continuing.
I read his testimony on that point as trying to establish his qualifications. And if that was his qualifications, that I've done these thousands of Rule 11 evaluations, why isn't it fair game to point out, for the state to point out, there is no Rule 11 here. This is not one of your wheelhouse issues, and keep going on with the notion that you're not as qualified as our doctor.
Well, this certainly is what the state did here. What I specifically have taken issue with is the fact that, once you establish that there was no Rule 11, report Rule 11 evaluation that was done in this case, or any reports records that would have been reviewed by the doctor, the only point to questioning and saying things like, well, so if there were records, you just didn't review them, and then arguing in closing that Dr. Kirby reviewed more voluminous records. That is the error here. Dr. Potts was, again, a very important witness, the only one testifying as to the wrongfulness, in Mr. Lujan's favor. And so I would also like to get to the question of the jury instructions. I know I have very little time left, but
can I ask you in particular about the carte blanche comment? What? There was an objection or a request, I guess maybe not an objection, not a contemporaneous objection, but a request for an instruction.
Yes.
Do you believe that is a correct statement of the law to say Dr. Kirby misstated the insanity law to you? A finding of insanity does not mean Mr. Lujan has carte blanche to commit crimes?
I do believe
Isn't that a direct comment on the evidence?
Well, in this case, what we know from
Well, doesn't our Constitution prohibit direct comments on the evidence?
Well, in this case, we already had in front of the jury that basically, he's going to get carte blanche from the state's expert, mind you, if he's going to avoid accountability. And so that needs to be corrected. We know from Cornell that is presumptively prejudicial. That is always improper for the jury to hear that. The jury did hear it, and so it should be corrected. I would also say that
But that doesn't answer his question. Judge Catani asked you if that was a correct statement, a correct instruction. And if it's an illegal comment on the evidence, how can the trial court give it?
Well, no, I believe that is a correct instruction. What basically, what Dr. Kirby was saying, and, how when you read it, there's no other way, I think, to read it than to say a GEI verdict in this case would mean that he would be getting away without accountability.
If your client had requested a more generic instruction versus a comment on the evidence instruction, it would have been appropriate.
I believe that the instruction that was requested was appropriate in this case, and I think that this is exactly the exception that U.S. v. Shannon says, that this would be appropriate. I would also point out that a case that was decided in the Ninth Circuit just a few days ago on November 28th also found that there was appropriately an exception in that case to where an instruction was properly given that did discuss consequences. I would like to save what little time I have
left. Do you
left.
have the name of that case? Sorry.
Oh, yes, I do. I'm sorry. It is
While you're looking that up, our federal brother and sister, they get to comment on the evidence, unlike we do. Right.
Yes, and this is, just persuasive and not controlling, but it's United States v. Denklau, Denklau, and the citation is 2025 Westlaw 3310761 from November 28th. Thank you. I'll reserve my 20 seconds.
All right. Thank you.
Good morning, Assistant Attorney General Michael O'Toole on behalf of the state. Mr. Lujan has not established error on appeal, let alone has he established reversible error, especially in light of the overwhelming evidence he knew right from wrong under a community standard.
Can we start with where we ended on the last one, and that's the carte blanche statement? Isn't that error?
It was an improper statement, certainly, and defense counsel should have objected. I think if defense counsel objected, the court would have stricken it. We could have moved on. By the time they objected, the trial continued on, so now we're talking about an instruction. It's not an abuse of discretion not to give the instruction at that point, because the court was very aware of both statements. The statement from Travis about capital punishment, and the court sua sponte struck that, but it basically felt the jurors weren't really that concerned about it. And then the same thing with Dr. Kirby's statement. The court said in the flow of the statement, I really didn't see anything improper. The question was certainly proper from the prosecutor, asking, is mental health the only element we have to establish here? And clearly, no, absolutely not. And then she added, unfortunately, too much.
Well, the brother also made a comment.
Right, he said that.
He always gets away with it or something.
Right, but if you look at that testimony, the defense, I think, was improperly asserting that the prosecution put him up to changing his testimony. They kept saying, was this entirely your idea? Entirely your idea? Suggesting the state was making. He goes, no, it was what happened. This is, he just basically expressed himself. So that statement, I think, was invited error because they kept pressing him, and they got the answer, which was a natural consequence of their questioning.
What do you're saying? There's zero remedy if you don't make a contemporaneous objection. There's no instruction that could have been given that would have ameliorated the carte blanche comment by the expert?
Well, the court did give an instruction not to consider punishment, and the jurors were well aware that they had to decide right from wrong as a central issue. Defense counsel, frankly, did a very good job.
But don't consider the fact that he's just going to get off completely carte blanche. Don't consider that.
Well, that makes no sense under the facts of the case, or just the facts that it's an insanity case, right? You have 3 verdicts: innocent, guilty, guilty except insane. Why do we have a difference between innocent and guilty except insane? I think the jurors know that something's going to happen to this guy. He's going to be committed. I mean, that's just the most common sense reading or conclusion from a guilty except insane verdict. And if you look at footnote number 10,
but you've had an expert say it shouldn't be carte blanche to.
Well, I mean, I think that the expert was talking about accountability, criminal accountability, which is the kind of the phrase that the other expert used when she was discussing, right from wrong in an insanity test. And if you look at footnote 10 in Shannon, the 1994 Supreme Court case, they're saying, maybe years ago jurors were kind of afraid someone would be let loose, but now in this day and age, we don't think that's the case. And that was a case where in the federal system, you have not guilty by reason of insanity. So that even kind of suggests that maybe the person's just not guilty and might go free. But still, in that case, they said, we don't want that instruction given. We want the jurors to focus on the factual determination at issue. And again, I point to voir dire. There was 2 places in voir dire, juror number 15 and juror number 42. And defense counsel did a nice job saying, I know sometimes people look askance at insanity cases. Does anyone here think that I'm just, this is a lawyer's trick or something? And then one juror spoke up and says, well, are we deciding what's going to happen? And after he goes, well, no, that's for the judge. He goes, oh, okay, great, thanks. And the same thing later on, another juror said, so the bottom line is we have to make this one determination. And this is open voir dire, and the counsel said yes. So it's very clear right from the beginning that they're making this one simple determination, and it's beyond speculation that would take some isolated statement that the trial court didn't consider problematic and the defense didn't object to.
Well, you consider it problematic.
I'm sorry?
You would agree that it's problematic.
Right, and I agree that if they would have objected at the time, it should have been stricken. But now we're talking a day later. Why go back and highlight something that no one really paid attention to in the first part? And again, the trial court seemed to be very in tune with the questioning, and he didn't sua sponte. It didn't sua sponte find it to be a problem like it did with the capital statement it struck, and the trial court didn't want to go back and highlight something that shouldn't be highlighted, especially given the instructions not to consider the punishment.
Does that cover it? Is punishment viewed as a remedy for guilty accepted insane?
Yeah, I know what you're saying because it's not necessarily punishment.
Right.
So maybe a better word is repercussion. But I think the case law has used that phrase as, repercussion. I think they kind of just used it synonymously. So
Was the defense requested instruction a correct statement of the law?
Well, the first instruction, the only one written, I think, was a misstatement of Travis's statement. The instruction given by the defense was Travis said that he would get away with the charged conduct, and that's not what he said at all. I mean, I think Travis was speaking out of frustration with a complex relationship with his brother who he thought always got away with things. So is he getting away with the, faking his military disability? I think, that's probably the most reasonable inference from the record. So that statement was not correct. And there was never, I don't believe, a written instruction proposed for Dr. Kirby's statement. And, the courts doesn't have a job to sua sponte, give its own instruction, I don't think.
Well, and on the brother instruction, that's a comment on the evidence to say, you've heard that's not acceptable. I mean, that's not how we do things in Arizona.
Correct.
Let me
Go ahead. No.
back to the Dr. Kirby testimony, and again, it is fair, I think, maybe to view a fact witness somewhat differently than an expert witness who, has done things like this before. But I thought the request by the defendant was instruction the day after, something like this. Dr. Kirby misstated the insanity law to you. A finding of insanity does not mean Mr. Lujan has, quote, carte blanche to commit crimes without accountability, close quote. And I thought that was Judge McMurtry's question as to whether that is an accurate statement of the law or not.
Well, I think that would be a comment on the evidence, too. So, again...
But it could have been massaged. I mean, there could have been an instruction based to eliminate the comment on the evidence to say an insanity defense does not give the defendant
There could have been a proper instruction, but I don't think the trial court has the responsibility to do that. And again, we're talking about something that happened the day before. There's not an immediate objection. I think the trial court thought it's best to move on. I think the facts and circumstances of this case indicate it was, and the court said, and the court carefully considered everything and had a fairly detailed ruling saying, I'm just going to say punishment is not, consistent with the case law. It's not for the jurors, and the jurors knew they were to focus on the right and wrong issue. So I don't think it was an abuse of discretion. I'd like to go back to the top of the argument and talk about the allegation that the prosecutors knowingly talked about evidence that wasn't true, and that goes to the urine test. The opposing counsel says, this test basically showed he was negative for meth, but it didn't. It showed there's no alcohol. He was positive for marijuana, and he was negative for amphetamine. Amphetamine. That's a different drug from methamphetamine. Now, counsel seems to think it's common sense or common knowledge that's the same test, or that a test for amphetamine, test for methamphetamine. That is nowhere in the record. So and defense counsel seems to assume below that it was. So I think you have the parties kind of talking past each other to some extent. And the prosecution's main point was the blood test, which did test for methamphetamine, was more than 24 hours. We don't necessarily know. And that's all they said. They didn't say he was on meth. They said, we don't know. We're not saying he was on meth. We just don't know. And then they moved on. We have two statements, basically, and about 80 pages of argument. And they went on to what does matter. What does matter is wrong from right. And in this case, there was no evidence whatsoever the defendant didn't know wrong from right. The only testimony was from Dr. Potts, who applied a subjective test saying he thought he had to protect his family, but from what? I mean, there's no delusions indicating that his family, his immediate family, his wife and children were at threat from his mother, father, and brother. His mother and father were in the house, his brother on the porch smoking a cigarette. If you felt any physical threat from these people, just drive away. There was no delusion justifying his behavior whatsoever. I laid out the evidence at length in the answering brief, and opposing counsel doesn't come back at it. She basically says, well, right from wrong was the issue, but now it's really, we have these collateral issues they had to think about. Well, ultimately, he's got to meet three things to show he was legally insane. Mental health defect, yes, okay. Then we have intoxication, well, who knows. And then he's still, even if he could show he wasn't intoxicated, he'd have to show he didn't know right from wrong. He's got to show all three elements, just like the prosecution has to show all elements. If the prosecution has 10 elements to prove, and they prove 9 out of 10, the defendant goes home. The same thing here, if he doesn't hit one of those elements, he doesn't prevail in his defense. And there's just no evidence whatsoever other than Dr. Potts' subjective opinion was not really evidence of legal insanity under Arizona law because it doesn't apply to community standard. I'd like to just hit a couple things on the other allegations of misconduct. With the more records allegation, if you look at the citation June 12, 24 at 43, the prosecutor is talking about Dr. Potts, didn't do an addendum, there's thousands of more pages, no addendum. Then he talks about Dr. Cavney, and Dr. Cavney was the court-appointed expert. She had a fixed universe, a one-time shot. More records came in, she didn't look at those. And then you have Dr. Kirby, who had more records. So the prosecutor was comparing Dr. Kirby to Dr. Cavney. There was no reference to Dr. Potts for that specific comment. And the pipe evidence, before even this was cleared up by the defense, the jurors were aware that the Eloy incident involved marijuana, and there was no reason to believe they thought the pipe from the Eloy incident was a meth pipe because it was a marijuana incident, and then it was cleared up by the defense, and it was cleared up again by Dr. Cavney when the defense said, just to be cleared, that was a marijuana pipe. Unless the court has further questions, the state has to affirm.
All right. No, thank you very much, Mr. Ogle. Counsel, take a deep breath and give us your best shot in 19 seconds.
19 seconds. Yes, Your Honor. I would say even if this was, this would be a direct comment to give the instruction. I mean, the judge had a duty to correct this once it was put on notice that this was a comment on punishment. This is stated in Cornell. It is presumptively prejudicial, and the stock instructions do nothing to alleviate the prejudice. With that, I would ask that this court reverse and remand for a new trial. Thank you.
Right. Thank you very much, counsel. Thank you for your briefing and your argument here today. The matter is deemed submitted. We'll issue a decision in due course. And with that, we are in recess.